Hi, my name is Corey Biazzo, and I'm a practicing American civil litigation attorney, and you are watching Executive Coup. In today's episode, we're going to discuss the July 10th, 2025 order issued by the U.S. District Court for the District of New Hampshire. This appears to be the first class action certification granted to a group seeking protection of the 14th Amendment birthright citizenships for infants. If you recall, as we discussed in episodes 2, 10, and 38, President Trump issued an executive order on birthright citizenship titled Protecting the Meaning and Value of American Citizenship that attempts to reinterpret the birthright citizenship clause of the U.S. Constitution despite the judicial branch holding the power of judicial review under Article 3 of the U.S. Constitution, not the President. Additionally, President Trump's executive order also attempts to nullify congressional statutes on this issue, despite the fact that Congress holds the power to legislate under Article 1 of the U.S. Constitution. Finally, executive orders do not have the authority to negate congressionally enacted laws or judicial rulings, such as interpretations of the U.S. Constitution, through the power of judicial review. The U.S. Supreme Court in 1898, in a case called United States versus Wong Kim Ark, interpreted the 14th Amendment birthright citizenship clause as providing for birthright American citizenship to those born within the physical United States, with the exception of children born to foreign diplomats who are in the U.S. at the time of birth in diplomatic service of another country, or to children born to hostile foreign invaders occupying American territory, such as a foreign army. An example in our history would have been if Japanese troops in World War II had children born in occupied parts of Alaska. Those children would have been excluded from birthright American citizenship, according to the U.S. Supreme Court. Neither the 14th Amendment nor the U.S. Supreme Court have stated anything regarding the immigration status of the parents of children born in the physical United States and whether they can be excluded from birthright citizenship. What we do know, however, is that regardless of how you feel politically about the issue of birthright citizenship, we are a nation of laws, not men. Article 5 of the U.S. Constitution requires 38 state legislatures or state constitutional convention votes, along with the majority of Congress and the President, to amend the U.S. Constitution. While it is hard to imagine that you could get close, even close to that much consensus on any political issue today, this is what our Constitution requires for amendments. If we allow a workaround for one elected president, who is to say that a future elected president of a different political stripe will not also abuse the workaround? Legislation, and especially amendments to the U.S. Constitution, are designed to be a consensus process, not a process where one authoritarian can alter the U.S. Constitution by executive fiat for everyone. In what appears to be the first major district court ruling since the U.S. Supreme Court's ruling in the birthright citizenship case covered in episode 38 that largely shut down nationwide injunctions but left a path for class actions, Judge Joseph LaPlante of the U.S. District Court for the District of New Hampshire issued a ruling on July 10, 2025, granting a provisional class certification pursuant to Federal Rule of Civil Procedure 23. The class action class consists of, quote, all current and future persons who are born on or after February 20th, 2025, where 1, that person's mother was unlawfully present within the United States and the person's father was not a United States citizen or a lawful permanent resident at the time of said person's birth, or 2, that person's mother's presence in the United States was lawful but temporary and the person's father was not a United States citizen or lawful permanent resident at the time of said person's birth. The language mirrors the people that are the target of President Trump's executive order in order to have them all included within the class. Additionally, pursuant to Rule 65 of the Federal Rules of Civil Procedure, the court entered a class-wide preliminary injunction in accordance with the U.S. Supreme Court's June 27, 2025 order on nationwide injunctions that again prevents the Trump administration from enforcing President Trump's unconstitutional Day 1 executive order on birthright citizenship. Check out episode 2 for a discussion of the substantive issues with the birthright citizenship executive order, which could make its way for final review by the U.S. Supreme Court later this year. Additionally, check out the amicus curiae brief that I submitted in this matter in the U.S. Supreme Court at www.biazzolaw.com and stay positive. Keep following Executive Coup for further updates on this matter and others related to the apparent executive coup attempt that is unfolding in the U.S. federal government at the direction of President Donald J. Trump. Thank you.